SEAL 26 missed the opportunity to receive treatment. He has a legitimate traumatic brain injury from serving his country. And his higher-ups are telling him, well, because you're not in compliance with their policy, you can't go receive treatment. Hello, everyone. My name is Joseph Radzwion IV, your trusted attorney with Radzwion Law, PLLC. And today we are talking about the case that came from Texas and how these brave men stood up for your freedoms and really showed that it can be done. For those of you who've been following the channel for any significant period of time, you know that we helped people, whether in the private sector or the public sector, file their religious exemptions under Title VII over the past couple years. We did so to help protect freedom, and this case shows that there is still a fighting chance if you want to stand up and be brave and courageous to take on these unjust policies. The mandatory cookie policies, as you can imagine, stemmed in late 2020, 2021, and have continued in some fashion through some corporations and some government entities. So we're going to look at a case again from Texas, and that's what we're bringing here today. So let's dive right in. This is the USN SEALs 1-26 v. Biden. It comes from the Northern District of Texas, Fort Worth Division. So just as a disclaimer, my license is only good for law in Michigan. I cannot speak to what Texas law is. For today's purposes, I am not going to give any legal advice. I never give legal advice in my videos. You should never take them as legal advice. You should always consult a trusted attorney with your legal questions. This case, we're going to just breeze kind of through the facts. Could imagine the background. The case arises from the United States Navy's mandatory cookie policy, and the plaintiffs are 35 Navy Special Warfare service members, including SEALs, Special Warfare combatant, craft crewmen, Navy divers, and an explosive ordnance disposal technician. Together they sue President Biden, Secretary of Defense Austin, and Secretary of the Navy Del Toro, and the United States Department of Defense. The factual background, as you can imagine, in August of 2021, the DoD issued a mandatory cookie policy directing all DoD service members to get said cookies injected into their arm. The Department of the Navy also implemented some such policy for service members, and there is a deadline of November 28th or face a full range of disciplinary actions. Special operations personnel refusing to receive the cookies based solely on personal or religious beliefs are disqualified. So the problem that we're going to see in this case is that the system that the Navy had put in place essentially made it impossible for a request, an exemption, to be approved. They made it so arbitrary and even admitted that it was just more or less to check a box, but no one was getting approved. Well, that violates people's religious freedoms and also federal law, as you can imagine. So for those with pending religious exemption requests, being disqualified means becoming permanently non-deployable. As you can imagine, becoming non-deployable as an active part of the military would pose problems. Unlike those with medical exemptions and allergies to the cookies, a non-cookie eating member seeking a religious exemption, the service member continues to be non-deployable even if they received the accommodation to not have to eat cookies or not get cookies put into them. Okay, so this wasn't just discrimination based on their accommodation, but even if they were granted such accommodation, they were still going to treat the members differently. But if you received a medical one, they weren't going to be treated differently. So as you can imagine, that's quite contradictory. So plaintiffs religious accommodation requests, remember this is the service members. These beliefs fall into the following categories: opposition to abortion and the use of aborted fetal cell lines in the development of the cookies, belief that modifying one's body is affront to the creator, direct divine instruction not to receive the cookies, and opposition to injecting amounts of animal cells into someone's tissue. Okay, plaintiff's beliefs about the cookies are undisputedly sincere, and not the role of this court to determine the truthfulness of the accuracy. That's good. We never want the courts, especially in cases of personally held beliefs such as religion, to actually try and dig into what someone believes or how accurate it is, because the court is not, that's not their job. That they're not pastors, they're not priests, they're not, that would be too subjective if they were doing that. Even so, as December 17th, the Navy had denied at least 29 of the 35 accommodation requests, the majority of which had been appealed. Skipping down, to adjudicate the accommodation request, the Navy used a 6-phase, 50-step process. Okay, and I'm not going to bore you with all of the different steps. I believe they're in here. If I recall reading through them, I did read all of this, but I'm just trying to highlight so you guys get the general flavor. Otherwise, we would be here all day. On November 9th of 2021, plaintiffs filed this lawsuit challenging the Navy's mandatory cookie policy. All right. So the legal standard, they challenged it with a preliminary injunction. For those of you who don't know what that means, this essentially means there's a pending case, and to maintain the status quo or change what the status quo is, depending on what you're trying to achieve, the one of the parties can file a preliminary injunction, having the court pretty much put the policy that's being contested on hold until the court is able to review it in full and make a decision. So a preliminary injunction was filed, and the test for that is if there's a substantial likelihood of success on the merits, a substantial threat of irreparable harm, which, you know, as you can imagine, would be them being terminated or not being able to be deployed while this is going on, and that there is a balance of that the balance of hardship weighs in the movement's favor, and that the issuance of the preliminary injunction will not disserve public interest. So those are the things that are required for the preliminary injunction. So the Fifth Circuit has developed a test to determine whether a given military issue is justiciable and appropriate for judicial review. That test requires plaintiffs to pass a 2-part threshold test by showing that an allegation of the deprivation of a constitutional right, or an allegation that the military has acted in violation of applicable statutes or its own regulations, and 2, exhaustion of available intra-service corrective measures. Okay, so I remember reading through this and thinking typically the courts don't get involved in military issues because the military has its own administrative process that one can go through to appeal issues or bring issues to light. The court here is saying, but if, number one, those remedies have been exhausted and there doesn't seem like the military has some sort of administrative process put in place to deal with these issues, and on top of that, there's some sort of deprivation of a constitutional right at play, that the court is more likely to at least review the case and see if they're going to take it on as a justiciable issue. So it goes on to say here that the defendants agree that the plaintiff satisfied the first part of the test, that the military was depriving them of their First Amendment rights and violations under the RFRA. The facts overwhelmingly indicate that the Navy will deny a religious accommodation, and that the Navy has denied 29 of the plaintiffs' 35 accommodation requests. Outside of the plaintiff's requests, the Navy has to date never granted a religious accommodation request for the mandatory cookie policy. In fact, in the past 7 years, the Navy has never granted a single religious exemption for any sort of medical procedure, okay? Several of the plaintiffs had been directly told by their chains of command that the senior leadership of the Navy Special Warfare has no patience or tolerance for service members who refuse a mandatory cookie the mandatory cookie policy for religious reasons and want them out of the SEAL community. Now, let's pause for a second. That is someone's personal opinion, and they inherently are being discriminatory against someone's religion at that point by just saying that they don't tolerate, what they're saying is they don't tolerate someone's religious beliefs. We want them out of the SEAL community. I'll tell you what, people who have a faith or a moral compass and are willing to sign up to do arguably be part of one of the hardest branches of the military service, to go over and risk their lives as part of their job, why would you want to exclude them from the ability for them to do that? That to me that's crazy to say something like that. That you would want someone so selfless to be excluded from your elite group when lives are at stake. That is just boggling to me. So under the standard operating procedures for the process, the first 15 steps require an administrator to update and prepare disapproval templates with the requester's name and rank. So this is getting into now kind of part of those 50-step processes, and how the Navy literally set up a process to make sure that anyone who submitted one of these would automatically it wouldn't be granted. The request would automatically be denied. Okay. So after those, let's see, go back here. In essence, the plaintiff's requests are denied the moment they begin. That's pretty, the law doesn't like that, especially in discrimination type cases. In essence, the plaintiff's requests are denied the moment that they begin. The prepared letter is then sent to 7 offices for review. After those offices review the disapproval letter, the administrator packages the letter with other accommodation requests for the final signature. The administrator then prepares an internal memo to Vice Admiral John Nowell, asking him to sign the letters disproving the requests based on sincerely held religious beliefs. So essentially, they were making the service members submit their requests in the format that they wanted them to submit them in a template that was already set up to essentially be submitted to these offices for quote unquote review, just to end up on some admiral's desk for him to sign off, disproving the letters. That's what's going on here. All right. So then after they get this letter, this signed letter from the admiral, then at step 35 of the process, the administrator is told for the first time to actually read through the accommodation request. But at this point, the disapproval letter has already been written, and the request and the related documents had already been reviewed by several officers. The disapproval has already been packaged with similar requests. They've already been put together in a package with a memo saying that Vice Admiral Nowell disapproves of these religious accommodation requests. The law does not tolerate for that. The federal law, the Constitution. So at no point in the process is the administrator given the opportunity to recommend anything other than disapproval. Right here in the green, right here. At no point in the process is the administrator given the opportunity to recommend anything other than disapproval. That is inherently discriminatory. Okay? So even if the religious accommodations were granted, plaintiffs will not receive the relief they seek. And this is part of the court's rationale as to why the issue becomes justiciable, meaning that they can hear it in the civilian court and pull it from the clutches of the military administration, is because even if the accommodations were granted, the relief the plaintiff is seeking, which is to be treated equally like everyone else, they're not going to be treated equally. All right. Again, the record was outlined with examples where they would still be deemed medically disqualified which would mean that they're permanently barred from deployment, denied bonuses and incentive pays that accompany the deployment, deprived of various reasons they chose to serve in the Navy. By contrast, those receiving medical accommodations for the mandatory cookies are not medically disqualified. They would receive equal status of those who did take the mandatory cookies. This was not just a bunch of higher ups saying, we don't like anyone who doesn't like our cookies. This was specific to, if your reason for not eating our cookies is faith-based, we have no tolerance for you. And that's what they said here, and the court cited this. But if you have some legitimate medical reason, we won't discriminate against you. You can be deployed, you can receive benefits, all that sort of stuff. But see, that logic is disconnected. If it really was about making sure people are quote unquote safe by having these cookies, and those who don't have the cookies are somehow there's some elevated risk, whether they're being deployed or whatever they're stationed at, you would think that you treat everyone without cookies the same, but they weren't. They weren't treating everyone without cookies the same. Again, moving on, some plaintiffs, I'm in the red section here, some plaintiffs were told by their chains of command that if their faith-based accommodations were approved, they would lose their SEAL trident, and others would lose their tridents merely for requesting the exemption. So you have two threats there. All right, for those of you who don't know what the SEAL trident is, a SEAL, when a SEAL becomes a Navy SEAL, they're issued a trident. It's like a shiny gold badge, essentially indicating that they went through some of the hardest training the military has, and that is their badge signifying that. They might wear it on their hats, or I think maybe on the lapels of their uniforms. But that trident is like the pinnacle of, I'm a Navy SEAL, this is my indication. They're saying, the Navy is saying, if you don't get your religious accommodations approved, we're taking that from you. We're essentially taking your ability to be a Navy SEAL from you. And on top of that, for those who already submitted them and we take them, for those who are thinking about submitting them, we're going to take them just for simply merely suggesting that you're going to submit this exemption. That is very coercive in nature. At the best, the available remedies would not accord plaintiffs second-class status in a peerless community. Thus, the available administrative remedies are inadequate. This is the court going through their rationale, giving their examples as to why they need to hear this case, because the military is clearly, their process has already been stacked against them. So the 4 Minds factors, this comes from a case. Having passed the threshold test, the plaintiffs must next show the Minds factors weigh in favor of justiciability. The factors are, number 1, the nature and strength of the plaintiff's challenge; 2, the potential injury to the plaintiff if the review is refused; the type and degree of the anticipated inference with the military function; and 4, the extent to which the exercise of military expertise. So I'm not gonna read all this. Essentially, if you want to see this, I'm gonna have this PDF on the blog page. But just to highlight kind of briefly those prongs, the nature and strength of the plaintiff's claim weigh in favor of judicial review, as the nature of the claim is constitutional in nature. Constitutional claims are normally more important than those having only a statutory or regulatory basis. So that's good that the court recognized that. The second is that the potential injury to the plaintiffs, if the review is refused, weighs in favor of judicial review. The loss of the First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. The court is very wise to say that when people's rights are denied, even for a brief period in time, that's an injury that cannot be remedied with money or with, time moving forward. All right. So the plaintiffs are continually suffering injury while waiting for the Navy to adjudicate their requests, right, in a system that's stacked against them. Here's a good example. One egregious example, Navy SEAL 26 was approved for a 4-week program in Maryland to treat deployment-related traumatic brain injuries. He told his commanding officer that he could travel in his own vehicle to the medical facility, which did not have a mandatory cookie requirement for its patients. Here's a Navy SEAL so dedicated, he's willing to spend his own time and money in his own vehicle, all right? His commanding officers told him he was not allowed to travel because he didn't have the cookie, all right? Now, it's not that he wasn't allowed to be in the building when he gets there. It's that he wasn't allowed to do the traveling to get there. So SEAL 26 missed the opportunity to receive treatment despite his pending accommodation request. SEAL 26 missed the opportunity to receive treatment. He has a legitimate traumatic brain injury from serving his country. And his higher-ups are telling him, well, because you're not in compliance with their policy, you can't go receive treatment. If that doesn't fire you up, I don't know what will. Third, the type and degree of anticipated interference with the military function weighs in favor of judicial review if the inference would be such as to seriously impede the military in performance of vital duties. It mitigates strongly against relief. But here's what the court is saying. But the interference per se is insufficient since there will always be some interference when review is granted. Over 99% of active duty Navy service members have the cookie. Whether denying religious accommodations violate the First Amendment is a distinct legal question that would not seriously impede the military in performing a vital duty. So the court is saying here that because they're going to review the case, the interference that the court is going to have in reviewing the constitutional issue of the First Amendment is not going to hinder the military from executing their missions. Okay, so there's that. That's good. Fourth, the court should defer to the superior knowledge and experience of professionals in matters such as promotions or orders directly related to specific military functions. This is not a suit in which commanding officers would have to stand prepared to convince a civilian court of the wisdom of the wide range of military and disciplinary decisions. So in sum, all 4 Mines factors end up being met. And what the court here goes on to say is that there is a presumption that the military will afford its members protections granted by the Constitution and do so in a manner that's not condescending. All right. So that's what they're going on here to say. And in futility, the plaintiffs need not wait for the Navy to rubber stamp a constitutional violation before seeking relief in court. The respondent was arguing and saying that, well, they're all pending. No decision has been made. But the court is like, well, we need to take this case because you've already admitted that you're not going to approve any of these things. Why should the plaintiffs, the service members, wait for you to just deny all of them and then have to file suit? The court is saying that these service members have a claim now. They have standing to petition the court now. They don't have to wait for you guys to deny them their First Amendment rights. You're already set up to deny them their First Amendment rights, and you've admitted that you're going to do so. So the court goes on to say that the plaintiff's loss of religious liberties outweighs the forthcoming harm to the Navy. And even in the direst of circumstances, one cannot justify the loss of a constitutional right. I want you guys to put that in your head. Even in the direst of circumstances, that circumstance cannot justify the loss of a constitutional right. Fortunately, the future does not look so dire. And then in conclusion, the court goes on and says that the preliminary injunction is granted and the defendants are enjoined from applying their policies and carrying out their arbitrary RAR 50-step process in arbitrarily denying people's RARs. So that is the case that I wanted to bring you guys today. I know it's a little bit longer than usual, but I think it shows some of the things that we were taking calls on in the office, which there were several military members that did not want to receive the mandatory cookies. This case was able to give them hope. We were able to discuss it with them and say, look, if you're willing to stand up for freedom, this is a case that it can be won. It can. It's an uphill battle, and you have to be willing to battle. And other people that were saying, well, once you join the military, you essentially sign over your entire life to them and they get to do whatever they want. Well, not really. The court here is saying that constitutional rights, you still have them as a military member. You can't give up those rights just because you decide to serve the country. That's what I bring you here today. I want you guys to leave us a comment below as to what you think about this case. Please use the word cookie instead of, you know what, we can't say the bad C word with the numbers after it, the 19 after it. Please do that. Hit the like button if you want to see more case reviews like this, and share this video with as many people as you can. These stories have been censored for the last 2 years, and there are plenty of them out there. We look forward to hearing from you guys in the comments, and until next time, thanks again for watching.